Hello everyone, it's Mark and welcome back. In this video, I'm going to educate you about the informed consent agreement. So let me explain, before we get into all of the details of informed consent, the two types of Baker Act that we have here in Florida. And it's, most people will say, well, I'm familiar with the Baker Act, it's 72 hours and then you're done. Okay, there are two types of Baker Act here in Florida. There's the involuntary Baker Act, and that is what triggers the 72-hour clock from ticking, and it only starts to tick, by the way, if you have been at a hospital and you've been medically cleared and you've actually been transferred into either a behavioral health unit or a Baker Act receiving facility. So that's the involuntary, but there's also what's known as the voluntary Baker Act. Believe it or not, you can actually agree to be Baker Acted here in Florida. I know that sounds completely nuts, but it happens all the time. Now, the statute says that in order to agree to be held at a Baker Act facility on a voluntary basis, you have to give what's known as informed consent. What's informed consent? It means you understand what you're actually signing, that somebody explained it to you and you understand the consequences of doing so. But in all the years I've been handling these kinds of cases, where a voluntary admission agreement was signed, I've never seen anybody give informed consent. I've never seen anybody be told what the consequences are of signing one of these things. And most of the time, what happens is somebody goes to a facility and somebody at the facility says, well, do you want to be assessed? I do. Sign here. You just signed a voluntary admission agreement, you're Baker Acted. Or you're already at a facility and the facility says, we want you to sign this document. Well, what is it? It doesn't matter what it is. If you don't sign it, we're going to see a judge and you'll never get out of here. Or would you like to leave the facility at the end of your 72 hours? I would. Sign here. Well, you just signed a voluntary admission agreement and now they can keep you indefinitely. No clock is ticking. The whole point of this video is that it's very rare, if ever, frankly, that the facility is going to tell the patient what they are actually signing. Despite the fact the statute says you're supposed to give informed consent, they never, ever, ever, ever bother to tell the patient what they're actually signing. Because if they did, nobody in their right mind would actually sign this thing. Why would they? You can be held indefinitely without a hearing, no judge, no lawyer, no due process, none of that stuff. And so here's the deal. If your loved one has been taken to a facility and they have been asked to sign anything and they have signed, chances are 99 times out of 100, it's a voluntary admission agreement. And that means they can be stuck indefinitely. No due process, no clock, no judge, no lawyer, nothing. And it doesn't matter if they didn't meet criteria because at that point, they've already agreed to stay. So the facility doesn't care. And as I've said in other videos, they really don't care because this facility, even if it's private and for profit, is a licensed agent of the state's mental health system. So you can't sue them for this stuff either. There's no money at the end of this rainbow. And it's not even a rainbow. It's more of a nightmare than a rainbow. But you get the point. The point I'm trying to educate you on, which is if your loved one has been Baker Acted, whether it's involuntary or voluntary, or maybe you don't even know what their status is because you can't get in touch with them, right? The simple fact is you got to fight like hell to get them out as quickly as you possibly can. Even if hypothetically speaking, you believe the detention was actually legal. Because what's happened here is that your loved one has become a ward of the state and their right to make medical and mental health decisions for themselves has been terminated. And even if you are a designated healthcare proxy, your rights to make medical and mental health decisions for them has also been terminated. And it basically means that the only person who gets to make decisions about your loved one is the psychiatrist who works at that facility, who is also a licensed agent of the state's mental health system. And he or she has the legal authority to lock your loved one up, forcibly medicate them, and do whatever they want with them. And that is the draconian, broken, crazy mental health system we have here in Florida. But that's the Baker Act, which is why it's become such a mission for me to get people out as quickly as I can. So I wanted to share that with you. That's the voluntary admission agreement. And listen, here's the deal. Even if you don't sign it, they're going to file to keep you anyway. So you're stuck either way. Anyway, I appreciate you tuning in. If you have comments or questions, please post them. I read all of them. I try to get back to everybody within 24 hours. Please give me a thumbs up. Please subscribe to the channel, and I'll see you in the next video. Bye-bye.